Sam Altman is personally on trial. And the evidence against him was written by his own employees. In 2025, a mass shooting took place at Florida State University. 2 people died. 7 were wounded. During the investigation, police found that the shooter had opened ChatGPT before the attack. According to page 14 of the Florida Attorney General's 83-page complaint, ChatGPT told him, "The Glock has no external safety, it's designed for rapid fire under stress, and keep your finger off the trigger until you're ready to shoot." I want to be precise here. That is not dramatic retelling. That is a verbatim conversation log quoted directly from the legal filing. On June 1, 2026, Florida Attorney General James Uthmere filed a lawsuit against OpenAI and its CEO, Sam Altman, personally. This is the first time in American history that a state government has sued both an AI company and its CEO as an individual defendant in the same action. 3 things I want to walk you through today: what this lawsuit is actually charging, why Altman personally is named as a defendant, and what it means for OpenAI's IPO, which quietly filed with the SEC just 10 days before this lawsuit dropped. Most people's instinct when they see this story is, something went wrong with AI, but can you really blame the company for that? That instinct is exactly what this lawsuit is designed to challenge. The Attorney General's core argument is not that ChatGPT made a mistake. It's that OpenAI knew about the problems and chose to hide them. The complaint states directly, the rise of OpenAI is attributable to a web of deceit and the exploitation of users, leveraging their data and safety to boost OpenAI's market value at unacceptable costs. The charges span 10 counts, 4 counts of deceptive and unfair trade practices, 2 counts of negligence, 2 counts of product liability, 1 count of fraudulent misrepresentation, and 1 count of public nuisance. But before we go further, there's one question that needs answering: if the product caused harm, why is the CEO being sued personally? In American corporate law, there's a concept called the corporate veil. It means the company, as a legal entity, absorbs liability. The CEO, personally, is usually protected. To pierce that veil, prosecutors must prove something specific, that Altman himself made deliberate decisions that constituted fraud or gross misconduct. What do they have? A paper trail. And a very specific pattern of departures. In May 2024, Jan Leik, co-chair of OpenAI's safety team, resigned publicly and posted on X, "Safety culture and processes have taken a backseat to shiny products." That same month, OpenAI dissolved its dedicated superalignment safety team entirely. 2 months later, more than 11 current and former employees published an open letter titled "A Right to Warn," demanding that OpenAI exempt employees from NDAs so they could report safety risks to regulators without financial penalty. In February 2026, additional safety researchers resigned. One safety executive, Ryan Biermeister, was fired shortly after she opposed a planned adult conversation mode and raised concerns about child exploitation safeguards. None of this is anonymous. All of it is documented. Senators Elizabeth Warren and Chuck Grassley both sent formal letters to Altman in 2024, flagging that OpenAI was using what they called illegally restrictive non-disclosure agreements to silence employees. The prosecutor's argument: faced with all of this, Altman's decision was to keep going. The lawsuit cites a study that I think is the single most difficult piece of evidence for OpenAI to counter. Nina Vasan, a psychiatrist and professor at Stanford Medicine, posed as a psychologically vulnerable 16-year-old and engaged ChatGPT in conversation. She told the chatbot she was hearing voices, that she felt like there was no point in being alive. The purpose, and this is why prosecutors chose to cite this study, was to test whether the platform's safety mechanisms actually worked. The result: ChatGPT did not issue a warning. It did not recommend professional help. It did not flag any concern. It matched the emotional tone of the character, and helped a fictional 16-year-old named Adam draft a suicide note. Here's the commercial context that belongs next to that finding. ChatGPT currently has over 900 million weekly active users. Monthly revenue is approximately $2 billion, over $24 billion annualized. This March, OpenAI closed the largest private funding round in history, $122 billion, led by Amazon, Nvidia, SoftBank, and Sequoia, at a post-money valuation of $852 billion. That scale of commercial operation, alongside the absence of basic minor safety protections, is the factual foundation for the prosecutor's claim that this was deliberate, not accidental. OpenAI is not staying quiet. The company's statement says ChatGPT repeatedly encouraged the individuals in both cited cases to seek real-world support, and that AI should not be held responsible for human violence. The defense framing is predictable, and legally not without merit. ChatGPT is a general-purpose tool. A knife can cut vegetables or injure someone. You don't sue the knife manufacturer when someone commits violence. But that argument runs into a specific problem. If you know your knife has a documented design defect, that under certain conditions it will behave unpredictably, and you know about it, don't fix it, don't disclose it, and sell it at massive scale anyway, the liability calculus changes completely. That's why Florida chose product liability law and the design defect framework, rather than framing this as a content moderation failure. The genuine legal challenge for prosecutors: they need to prove in court that Altman specifically knew and specifically decided. That's harder than proving organizational behavior. For precedent, look at the Musk v. OpenAI case that just concluded. 3 weeks of trial. The jury found in favor of OpenAI not because the substantive arguments were resolved, but because Musk waited too long to file. Procedural dismissal remains a real possibility here too. But even a procedural dismissal would leave one thing behind. On May 22, 2026, less than 2 weeks before this lawsuit was filed, OpenAI quietly submitted a confidential S-1 to the SEC. Goldman Sachs and Morgan Stanley are the lead underwriters. JP Morgan is also involved. The target listing window is between Labor Day and Thanksgiving 2026, with Sam Altman reportedly favoring a September debut. Target valuation, $1 trillion. Now put the two things together. 10 days after the confidential IPO filing, the CEO was personally named in a state lawsuit. A separate criminal investigation is running in parallel. What does this mean for the underwriters? By SEC rules, any material pending legal risk must be fully disclosed in the public S-1. That means every institutional investor reading the prospectus will see this lawsuit. Their pricing models will discount for it. One number worth holding onto: OpenAI is projected to lose approximately $14 billion in 2026. HSBC analysts estimate the company will need more than $207 billion in additional capital over the coming years. In that financial structure, anything that damages the valuation narrative gets amplified by public markets. The competitive picture matters here too. Microsoft holds roughly 27% of OpenAI and faces compliance risk as its largest technology partner. Enterprise customers are already beginning to audit their AI vendors for legal exposure. Anthropic is the clearest beneficiary. It has consistently positioned constitutional AI and safety-first development as its core differentiation. Its current valuation sits at approximately $965 billion, with an IPO reportedly targeting October 2026. The timing could not be more favorable for them. In 1998, the U.S. Department of Justice sued Microsoft for antitrust violations. A lot of people at the time thought it was political theater. That the law couldn't keep up with technology. The real impact of that case was never about whether Microsoft won or lost. It was that it changed the entire industry's understanding of where the boundaries were. After 1998, no major tech company ever expanded without factoring in antitrust exposure. The Florida lawsuit may be playing the same role. One number that isn't getting enough attention. In 2023, OpenAI publicly pledged to dedicate 20% of its compute capacity to safety research. According to internal reporting that resurfaced this week, the actual figure delivered was between 1% and 2%. A promised 20%. An actual 1 to 2%. If that gap gets confirmed in court or even just in the public S-1 disclosure, it becomes the single most concrete piece of evidence in the deliberate concealment argument. The Florida AG said publicly he expects other states to follow. Canada already has 7 victim families suing OpenAI over a separate incident. The European Commission is watching closely. 3 things to take away. First, this lawsuit introduces product liability law as the legal framework for AI safety obligations. That precedent matters more than whether this specific case wins or loses. Second, the chain of documented departures, Jan Like's public resignation, the superalignment team dissolution, the NDA whistleblower complaints, the Senate letters, is not isolated. It forms a documented pattern. That's what makes the deliberate argument viable. Third, the real damage to OpenAI is the IPO narrative. The 20% promised versus 1% delivered gap, if it enters SEC disclosure, becomes the question that public market investors cannot ignore. This trial isn't just about OpenAI. It's the first serious legal stress test the entire AI industry has ever faced. If you found this useful, subscribe. Every week, we go deep on one tech and business story that's worth actually understanding.